Your Honour, I submit that this expert report should not be admitted into evidence on the grounds that it contains inadmissible hearsay, lacks the requisite expertise specific to the antique firearm in question, does not follow standard forensic protocol, and ultimately fails to meet the reliability standard required in criminal cases. If it please the court, I have broken down our concern into 5 separate issues.
Go ahead, Mr. Collins. However, in the future, try not to signpost so much.
Firstly, hearsay. Your Honour, the report contains multiple hearsay statements that do not fall within the exception and should, therefore, be excluded. Drawing attention to paragraph 16, the expert recounts statements from Detective Sergeant Mulhaven regarding the firearm being seized from the scene of a homicide. Further, in paragraph 17, Sergeant Mulhaven allegedly states that the gun was fired by Mr. Douglas to kill Barry Clemson. These statements are hearsay. They were made out of the court and now are being introduced into the court to prove critical facts of the case, and that the firearm was used by Mr. Douglas in a homicide. This is, we feel, an opinion. Ms. Power is only being asked for her opinion on specialised knowledge in relation to firearms. Any and all opinions that she may have outside of that, we feel, cannot be made admissible in relation to her producing evidence.
What is your authority for this?
Yes, Your Honour. Authority for this view comes from Section 79 of the Evidence Act 2011. Additionally, there is precedent at common law as outlined in R. v. Hein Phuc Tang, 2006, New South Wales CCA. Justice Adams outlined that an opinion of an expert had to be related to his or her expertise. By allowing Ms. Power's report to be admitted as is, we feel has the potential to imply a narrative of guilt towards Mr. Douglas. We feel that the probative value of the statement is outweighed by the danger of unfair prejudice being placed on Mr. Douglas. The main authority in our reasoning comes from Section 137 of the Evidence Act and a recent case of Marshall v. the King, 2023, where at 53 it outlines that there is a danger that a jury might make an improper use of the evidence if it was to be submitted. These are our concerns in relation to hearsay. Secondly, Your Honour, we submit that there is inadequate expertise on antique firearms. Your Honour, while the expert has extensive experience in firearms and munitions, they lack specific expertise in antique firearms. The expert openly states in paragraph 21 that they have never handled this particular type of shotgun before, and they struggled even to assemble it. Given the unique mechanics and characteristics of antique weapons, someone without a specialised background in the area may lack the competence to assess this firearm accurately. Turning to section 1202 of the Court Procedure Rules 2006, an expert in relation to proceedings is someone who has specialised knowledge about the relevant issue and be qualified to give their opinion as an expert. Ms. Powers states in 3 separate paragraphs, those being 19, 20 and 21, that she has never seen, handled, nor even assembled this type of weapon. She stated herself in paragraph 20 that she is based her analysis on other expertise of a second-hand information that she obtained through other people or through a phone conversation with the one Mr. Vincent De Maio. Returning to section 1202A, subsection A and B of the Court Procedure Rules 2006, Ms. Powers in this instance cannot declare that she is an expert in relation to the weapon in question based on her training, study or expertise, and she is not qualified to do so in this matter. Thirdly, we feel there is an issue with forensic methodology and chain of custody. The handling and analysis of the firearm do not adhere to standard forensic protocols, raising concerns about the reliability of this report. In paragraph 18 of Ms. Powers' statement, she details that the firearm was not stored in a sealed bag and that the expert did not sign any acknowledgement upon receiving it. Chain of custody is essential in criminal matters to ensure that evidence has not been tampered with or contaminated. The lack of standard documentation in this case compromises the firearm's evidentiary integrity. Without a proper chain of custody, this report cannot be seen as a reliable forensic examination, undermining the weight and admissibility of the conclusions drawn within. Should it please the court, I would like to request that the aforementioned chain of custody form be submitted to the court to highlight this disparagement. As outlined in section 4053 of the Court Procedure Rules 2006, this form should be in the register as it relates to the shotgun. Should we see that Ms. Powers was indeed handed the weapon without indicating on the chain of custody documentation, then her expertise in this matter is called into even more question, as we don't even know which weapon she actually looked at.
Could it be circumstantial evidence?
We believe not, Your Honour. Drawing from the common law by Justice Dawson in Shehad versus the Queen, they stated that circumstantial evidence is evidence of a basic fact from which an inference can be drawn. However, this inference must be drawn from an intermediate factual conclusion. In this instance, we argue that we do not know for certain which weapon Miss Powers examined, and therefore a factual conclusion cannot be built upon. Fourth, personal bias. Additionally, Your Honour, the report includes subjective statements that could indicate personal bias, as well as reference to hearsay and external opinions that do not meet forensic standards. In paragraph 20 of her statement, Miss Powers relies on an informal conversation with others regarding the reputation of this shotgun model rather than an independent analysis. The firearms expert's credibility is questionable under Section 108C of the Evidence Act, as their subjective endorsement of Detective Sergeant Mulhaney's truthfulness lacks the objective basis required for expert evidence. Although Section 108C allows certain credibility opinions by those who do have specialized knowledge, the expert's statement relies on informal personal judgment rather than rigorous forensic analysis. This reliance on personal opinion instead of verifiable expertise suggests a risk of bias and falls short of the standard for admissible expert testimony. Furthermore, when examining Miss Powers' comments in paragraphs 16 and 17, she on multiple occasions was told that this weapon was involved in a homicide, the nature in which it was fired, and who fired it. Should this report be admitted into evidence, it would count as 3 instances of hearsay statements. This is outlined in Section 59(1) of the Evidence Act 2011. The court is being asked to accept the statement of a person who heard a statement from someone else and then allow that to be entered into evidence. Precedent for this is outlined in R. v. Green, 2019, ACT Supreme Court, in relation to second-hand hearsay.
And lastly, Mr. Collins.
Good. Lastly, we have conclusions beyond expertise and speculation on defendant's state of mind. Lastly, Your Honour, in paragraph 26 of her statement, Miss Powers offers an opinion about what actions a stressed or fearful person would take, ascertaining that they would consider other options before assembling a firearm. This opinion ventures into the mental state and hypothetical behaviour of the accused, a matter outside the expert's forensic scope and competence. Courts have held that expert witnesses must confine their opinions to their area of expertise rather than speculating about the defendant's intention or mindset. Such speculation is not only beyond the scope of this expert's training, but could also unduly influence the court's interpretation of Mr. Douglas's actions, like to create an inference about the state of mind of the defendants. Authority from this comes from Section 79(1) of the Evidence Act 2011.
Is there precedent for this?
Yes, Your Honour, this was highlighted in Honeysett v. the Queen, 2014, High Court case, which speaks to the opinions of an expert being made in a way that makes it possible for a court to determine that it is so based. In this instance, Miss Power is not an expert in behavioural psychology, nor does she hold any qualifications of any kind related to behaviour. She was not prompted or asked to give her opinion on what a stressed or fearful person could do. Thank you, Your Honour.
Thank you, Mr. Collins.